Miss Mason, really
Mhm.
quick before you mute.
Uh-huh.
Um, so what we're gonna need from you, right now, since this is virtual, make sure that your phone is stable. Don't be walking around your house or none of that. That's what the judge requires, okay? Make
Okay.
sure you have a stable internet connection. Um,
Mhm.
Otherwise, if your internet doesn't work or whatever the case be, then the judge will just cut the cord out, okay?
Okay.
Obviously you
Because
don't
it's
want that.
been, well, just
Yeah.
FYI, I have not had no issues with my
Okay.
internet, my tablet, every, so if it do it today, that's just like, wow, what a coincidence. But
Right.
I haven't had no issues. But thank you for letting me
No.
know.
Okay, so we're on the record for August 7th, 2025, and we have two cases on the docket today. One defendant, but two cases. Um, Ms. Mason, you're going to have to turn on your audio if you would, please. And these are cause numbers um, LBZ 588-056-1250 and LBZ 588-056-1359, both style of the state of Texas versus Barbara Faye Mason. Ms. Mason, are you able to hear? She says she can't hear you. Okay, well, her internet's not. Ms. Mason, you're going to have to turn on your audio and yeah. Okay. Well, Ms. Mason, the problem is we can't do virtual if your technology doesn't work. And so the request to do this by, yeah, okay. Ms. Mason, unless you can get your audio to work, we're going to have to reset your case and you're going to have to appear in person. All right. Would you send her? I don't know. It's not me.
But it is you. So much for your perfect internet connection.
Well, Ms. Jordan, my audio is working. My video is working. You're going to need to send her a message saying that unless she can get her audio to work, we won't be able to do this by Zoom, and she will have to appear in person. Well, I'm not sure what to tell you, Ms. Mason, but yeah, ours is working on this side. Ms. Jordan, are you able to hear me?
Every word.
And Officer Edge, are you able to hear me?
Yes, sir, I can hear you.
Thank you. Ms. Mason, while the other people on the Zoom call are able to hear me, but if you can't communicate it, okay.
You may be trying to log in on her phone.
Your Honor, we're going to have an exhibit in this case. While she's logging in, can I bring that down to have that emailed to her?
Yes.
Before we even get into the courtroom fireworks, let's set the stage here, because this isn't just a traffic ticket case. This is a masterclass in how not to conduct yourself in court, virtual or otherwise. What you're about to witness is a defendant who walks into a legal proceeding convinced that rules don't apply to her, deadlines are optional, and accountability is somehow negotiable. From the very beginning, you can feel the tension brewing, the subtle entitlement, the defensive posture, and that unmistakable belief that if something goes wrong, it must be someone else's fault. And trust me, this case escalates fast. Technology issues, courtroom etiquette breakdowns, and a judge who has clearly seen this behavior 1,000 times before, all of it collides into one unforgettable hearing. Stick around because the contradictions, the excuses, and the emotional whiplash that follow make this one of those cases where every minute matters. And fair warning, this is only the calm before the storm.
Ms. Mason, it sounds like, or it looks like you're having internet issues, and if we can't hear you, whether it is on one device or another, if we can't hear you, then this can't proceed, and we'll have to set this case for an in-person trial. And I understand that you're telling me that it's our side, but both the parties, the state and their witness are able to hear me.
Sir, can you hear me?
I can.
I find it very strange that I have not had any problems at all until you came on, and now all of a sudden my audio was messed up. But I logged on, and now everything is working fine. That's I guess that's technology for you.
Yes, ma'am.
I'm ready.
Well, I don't know what your
I'm having to use two phones. My tablet was working fine. I had just told the what is the deputy before he was explaining to me. He said, make sure your internet and all that was working. I have not had any problem with my internet until you popped up. I just find that weird.
well,
And I guess
I'm not
that's
sure
just
if you're. Yeah,
it's a technical thing.
yeah. I don't know. Yeah, I'm not sure what my addition to this call caused or created, but I am an essential part of this process, and so. Ms. Mason, have you received a copy of the complaint? That's the written charging instrument. Have you received a copy of the complaint in this case?
I just received it in email today. Let me stop one of these. Hold on.
All right. And so at the appropriate time, I'm going to ask the prosecutor to read the complaint, and then I will ask you how you want to respond to the charge. In this case, there are two cases. There is a failed to signal charge and there's a failed to display charge. And so I will ask you, just, pardon me?
I only received the driver's license, the one for the driver's license. I didn't receive the complaint for the illegal turn.
All right, well, we'll send that to you.
Okay.
So, Ms. Ms. Mason, you are not represented by a lawyer today, correct?
No, I have no money. I don't have money for a lawyer.
Well, the court is not allowed to assist you in the presentation of your case. I can't tell you what questions to ask. I can't tell you if or whether you should testify yourself. I'm just not allowed to help you in the presentation. Do you understand that?
I do.
Okay.
And like I said, I'm not a seasoned police officer or prosecution. I'm only a person, that does right by the law. So I can only do my best.
Well, the reason I tell you this is that I just want you to understand I'm certainly not going to help the state, but I also can't help you in the presentation of your case. Okay.
Trust me, I know Denton County well. I know you can't help me. I know you can't. And I know that I'm doing this alone.
Right here is where reality starts knocking. and our defendant is already struggling to answer the door. Virtual court isn't a casual FaceTime call. It's a legal proceeding with rules, expectations, and consequences. The judge and court staff are doing exactly what they're supposed to do: confirming audio, ensuring everyone can hear, and establishing a proper record. But notice the pattern forming early. Every technical hiccup is immediately framed as not her fault. There's no pause for self-check, no acknowledgement that maybe, just maybe, her setup isn't working. Instead, we get defensiveness layered with disbelief. This matters because credibility starts here. Judges don't just listen to what you say, they evaluate how you say it, how you respond to obstacles, and whether you accept responsibility when things don't go smoothly. And from the jump, Miss Mason is signaling resistance rather than cooperation. That tone is going to follow her for the rest of this hearing, and it's not doing her any favors.
And so, at the appropriate time, I'm going to ask the prosecutor to read the complaint, and you have the right to call witnesses on your behalf. You have the right to testify on your behalf, but you have no obligation to put on any sort of case whatsoever. Do you understand that?
What do you mean by put on case? I don't know what you mean by that.
Okay. What I mean by that is you have the right to testify and tell me what you want me to know. Tell me what, to offer evidence on your behalf, but you're not obligated or required to do that. That the state has the burden of proof in this case against you, and they always have the burden of proof. And so you're not obligated or required to say anything. You have the right to say and to testify on your behalf, but you're not required to do that. That's my point in explaining this to you. Okay?
Okay. And let me ask you some. I want to go back to the first time, and when I had my first court, when I asked for the dash cam video and his body cam video, because those actually prove my point. And I was told by the lady prosecution that I didn't get to get that. I had to bypass all that because I missed it. So therefore,
okay, when we send out a notice for court, we send it out with a lot of lead time to tell the person, if you're going to request discovery in the case, that we have to reduce that request to writing. You have to serve it on the other party. That in this case it would be the prosecution, and it has to be done at least 7 days before the hearing. And if you didn't do that, then you waived that right to request discovery. Now, she has an obligation to provide any exculpatory evidence, make you aware of that. But if you don't make a timely request, then you lose that right to file that, or you lose the right to have that discovery prior to the day of trial.
So my question is, you're basically telling me that because that was missed, I don't get to get the proof that I need. What I'm getting ready to tell you what he said and did, and it's all on his dash cam and his body cam of the interaction that we had. So I'm just making sure, and I'm sorry, I'm not, like I said, I'm not a seasoned prosecutor or defense attorney, so I have to know this.
Well,
if you don't mind.
What I'm telling you is that had you brought this issue up, so I'm responding to you. Had you filed your motion for your request for an inspection of the video prior to the day of trial, you would have been able to get that information before the day of trial. Okay.
So that's a no, right? So that's a no. I won't be able to get
if the prosecutor presents it, you have the right to use that and to point out if there are any inconsistencies. You have the right to use that as part of your case.
Okay, so let me ask you another question. So you're basically saying that the complaint that I got, because I missed requesting that. So the only thing that we're going to go by is what he's saying. What's on that document and what's on the ticket.
That's not what I'm saying.
This moment is crucial because it exposes the core mindset driving everything that follows. Instead of addressing the technical problem pragmatically, the blame shifts outward, first toward the court, then subtly toward the judge himself. That's a dangerous move in any courtroom. Suggesting that the judge's presence somehow caused your internet issues isn't just illogical, it's disrespectful, even if unintended. Judges are human, but they're also authority figures tasked with maintaining order, and they notice when someone refuses to take ownership of basic issues. What makes this worse is the contradiction. Moments earlier the internet was perfect. Now it's mysteriously sabotaged. This isn't about technology anymore, it's about accountability. And the judge, calmly and professionally, doesn't take the bait. He redirects back to procedure, reinforcing that the court cannot bend around personal inconvenience. This exchange quietly sets the tone. Excuses won't override process and frustration won't replace compliance.
Okay.
That's not what I'm saying. I'm saying that the state has the burden of proof in this case, and they will present their side of the case. When they rest, you have the right to present your side of the case.
Okay.
And you can tell me what happened. You can present evidence. You can call a witness if you want to, and whatever evidence is admitted, the court will consider that and review that and use that to make a determination if the state has met its burden of proof in this case. Okay, that's how this process works. And so I'm not saying you can't present your side of the case. I'm saying that the opportunity to review the dash camera video and the body camera video prior to the day of trial was waived because you didn't follow the instructions we gave you a month and a half before you're supposed to have a hearing. That's
I didn't follow the instructions. Hold on. I didn't follow.
No, ma'am. No, we're not going to continue to do this. There's been a ruling on it, and when a judge makes a ruling, if you disagree with it, you can appeal it to a higher court. That's how the process works. And so, you don't.
Court? Are you
Pardon
saying
me?
a Texas court? Republican Texas? Come on, Judge. Okay, let's go ahead.
Ms. Mason, those are. We're not going to do this. I'm not going to have you make sidebar comments throughout this trial. We're not going to do that. And I'm going to ask that you use this or go through this process orderly. I will give you an opportunity to present your side of the case, but I'm not going to have you make sidebar comments. Please. Now, Ms. Jordan, would you please read the complaint part? I'm sorry, let me back up for a moment. Do you have any pretrial motions that you want to present at this time?
We do, Your Honor. It's the state's understanding that Miss Mason appeared for trial previously, and when she appeared in person for trial, the case was reset, and she asked that the next setting be on Zoom. And so we would like to put on the record that the state has no objection to proceeding with this trial on Zoom today, and make sure that all parties are in agreement of Miss Mason's request.
Well, if she requested it and you agreed to it, I think we're.
Yes, sir. I believe there's some law that indicates that there has to be an agreement on the record for Zoom, and so I just want to make sure we have everything perfect.
All right, Miss Mason, you did request a trial by Zoom, correct?
Well, that was
Virtual
after
trial.
you gave me that option. You gave me the option when we reset the court.
Yes, ma'am. And so you elected this option, correct?
Yes. Yes.
All right, very good. Thank you.
Thank you, Your Honor. Our second request is we're asking that the court takes judicial notice of the fact that Ms. Mason did not request discovery either directly through a motion with the court or through a request directed directly to the state. We would ask that judicial notice be taken of that fact.
Granted.
Thank you, Your Honor. No further pretrial motions for the state.
Ms. Mason, do you have any pretrial motions? These are motions prior to the beginning of the presentation of the evidence. Do you have any pretrial motions you want to make at this time?
Well, as I stated, I'm not a seasoned prosecutor, but I did when I did find out, read the paper. This was not stated to me while I was in court. It was written on your paper that I had to read. My understanding was that the court was being reset. And at that time, I could ask for it then. That was when I was told by the prosecutor that I missed that time. Okay? So that was my pre-trial. That's what I wanted to see the dash cam and the his body cam, because that was my truth. That I was profiled, not only profiled, but he stalked me.
Yes, ma'am. Well, what are you asking for at this time?
Well, you stated to me before that I couldn't ask for that anymore. So I'm basically just blindly trying to state my truths and just tell the truth.
Yes, ma'am. You'll have an opportunity to do that in just a little bit. When
Okay.
the state, because I said earlier, because the state has the burden of proof in this case, she's obligated to present her side of the case first. Then you have the right to respond. You have no obligation to respond, but you have the right to respond. And at that point in time, you can cross-examine any witness. You can present whatever evidence you might have in your case. Okay?
Okay.
Ms. Jordan, would you do you want to make an opening statement?
Your Honor, the state waives opening statement, but we would like to present or ask the court to admit into the record State's Exhibit number 1, which has been labeled State's Exhibit 1A through State's Exhibit number 1G as a self-proving document.
We're going to have to get Ms. Mason a copy of this, since we're doing this by Zoom, and this is confidential information, or at least private information. I don't want to present this on the screen, and so we're going to need to send this to her by email so that she understands and can respond to your offer of State's Exhibit number 1.
Yes, Your Honor.
Ms. Jordan, can you do you have an electronic copy of this?
I do not. I have to request a physical copy from DPS, and they send one through the mail. Your Honor, would you like me to continue on with testimony with the officer, and then I can revisit that once she's received it?
Let's go ahead and do that.
Yes, sir. The state has no opening statement.
All right. Ms. Mason, you'll be allowed, or you'll be permitted to make an opening statement once the state has finished its side of the case and rested. At that point in time, you can make an opening statement, or you can proceed directly with your evidence in the case. Okay? Ms. Jordan, you may call your first witness.
Thank you, Your Honor. The state calls Officer Edge to the stand.
This is one of the most misunderstood moments for self-represented defendants. The judge isn't being cold or dismissive. He's drawing a legally required boundary. Courts cannot coach one side while remaining neutral, and many people walk into these hearings believing fairness means guidance. It doesn't. Fairness means equal application of rules, not equal experience or comfort. Miss Mason acknowledges she's not a lawyer, but there's an underlying expectation that the court should compensate for that. The judge is crystal clear. The burden is on the state, but strategy, objections, and evidence presentation are her responsibility. This is where preparation matters, and unfortunately, we're already seeing the consequences of arriving underprepared. The court is patient, but patience doesn't erase procedure. This explanation isn't a warning, it's a lifeline, and whether she understands that fully is about to become painfully obvious.